Hello everyone. So in the last video, we had discussed Unit 1 of Partnership. Today we are going to discuss Unit 2 of Partnership Act. So since the first topic here in Unit 2 is minor, let's talk about that. When we talk about a minor cannot become a partner of the firm, but he can be admitted to the benefits. Now, when he becomes a beneficiary, what are the rights of the minor? Will he get his share of profits? Yes. Can he check, inspect, and copy the accounts of the firm? Yes. Can he sue the other partners for his share? Yes, provided he severs all his connections with the firm. Now, when a minor becomes a partner beneficiary of the firm, he can never have a personal liability. However, his liability is up to his share in partnership. When he becomes a major, can he continue as a beneficiary? No. So, within 6 months from the day he attains majority or the day he comes to know he was a beneficiary, whichever is later, he must give a notice of whether he wants to become a partner or not. What happens if he fails to give notice? He will automatically become the partner of the firm. Now, when he becomes a partner, he is liable from the day he was admitted to the benefit. That means, as a beneficiary, whenever he has joined, he is liable from that date for all the acts of the firm. Now, what are the rights of a partner? Will he have a right to take part in the business? Yes. Unless the agreement stops him, he has a right to take part in the business. Does he have a right to be consulted? Yes. Partners cannot take any decisions without consulting every partner. If it is a managerial decision, I need the consent of all. But if it is a day to day business, I need the consent of majority. Can he check, inspect, and copy the accounts of the firm? Yes, but it should be done bona fide. Will he get share of profits? Yes. Sharing of profits ratio and everything we had discussed in the previous one when we were doing sharing of profits as an essential. But just one question: does every partner have a right to share exclusive profits? No. Because if every partner shares profits, who will bear the losses? But can we have some partners who will not share the profits? Yes. Now, what is the next one? Can every partner have a right to claim remuneration? No, you're doing the work of your partnership. How can you claim remuneration? But remuneration is payable if the agreement stays or if it is the custom of the firm. Now, the next is, does he have right to interest on capital? No, because you are investing capital and you are getting profits. And that profits is a return on your capital. So you cannot safeguard your capital by getting interest on it. However, interest on capital is payable if there is an agreement or if it is the custom of the firm or if there is a statutory provision. One more thing, interest on capital is only payable out of profit. So if the firm suffers loss, we don't pay any interest on capital. And interest on capital is payable only up to the day the firm is operating. So the day the firm stops operating, we stop paying interest on capital. Interest on advance. Advance is something which is bought in by a partner over and above his capital. Is it payable? Absolutely payable at the agreed rate. And if nothing is agreed, it is payable at the rate of 6%. And it is payable even if there is a loss. Obviously, you cannot say, I have earned loss, so please don't take interest on advance from me. Obviously, that is not how it works. And it is payable up to the day you don't repay the loan. Then every partner has a right to be indemnified. So if a partner has paid on behalf of the firm, he has a right to be indemnified on behalf of the firm. Then duties. Can we say it is the duty to take care of the business, to do the business in the common advantage, to use his skill for promoting the business, not to leak, not to tell anyone else about the secret informations of the firm. If any partner or the legal heirs of a partner ask for an account, to give them a copy of the account, not to claim remuneration for doing the work, then not to make secret profits from the firm. And if you do, give it to the other partners. Not if because of your fraud or negligence, the firm has suffered any loss, you must compensate for the loss. What is partnership property? Partnership property means that property with which we start our common business. Apart from that, during the course of the business, if we acquire any other property, that is also considered as partnership property. Again, if a partner's personal property, one more thing, if a partner withdraws cash from the firm and he purchases a property in his own name, the fact that he purchased the property in his own name does not make it the property of the firm, does not make it the property of the partner. It is the property of the firm. And partner's firm's property shall be exclusively used only for the purpose of the business of the firm. And if a partner gives his personal property to the firm, it does not become the firm's property. It is his property and he will get interest on advance, or his share will be treated as a loan and he will get interest on advance, or he will get rent for that property. Now, personal profits earned by a partner. If a partner earns any personal profits from any transaction of the firm or by using the name or assets of the firm, from any transaction of the firm, or I use the firm's name, or I use the firm's assets and I earned a personal profit, I have to give a share of it with the to the other partners. They're only talking about profits, not losses. Losses are yours. Profits may we are bhai, right? Can the agreement, or let's say a partner is carrying a personal business which is competing with that of the firm, he must give a share of it to the other partners. Now, the next question that is, can the agreement say that a partner cannot carry any personal business? Yes, because you are getting remuneration for doing the firm's work. So we can stop you from doing the same business as that of the firm. In that case, if a partner still carries a personal business, then in that case, he is not liable to give damages. He's not liable to give profits if the partnership business and his personal business is not competing. But because you have breached the contract, you are liable to give the damages. Now, when we talk about change in the constitution of the firm, now what happens in case of change in the constitution of the firm? What is this change in the constitution of the firm? Any partner comes in, or a partner, existing partner goes out, or after the term is over, or after the purpose is over, we continue the business, or we decided to start one business but we ended up starting some other business. In all of these cases, the rights and liabilities of the partners will remain the same. Moving on to the next one. I did not even realize that it scrolled. Now, what is implied authority of a partner? Implied authority of a partner. See, a partner for the purpose of the business of the firm is both the agent as well as the principal of the other partners. And while acting in the ordinary course of the business, if he does any act, the act shall bind the firm. But when he does the act must be done in the ordinary course of the business. Okay. It must be done in the name of the firm. And as I said, it must be done in the ordinary course. If the act is not done in the ordinary course, the firm is not liable. But if the act is not done in the ordinary course, but the other partners ratify it, the firm is liable. So when we talk about, this is institute ka, yes, this is one topic you should know. When we talk about implied authority, whenever you get a question on implied authority, please start your answer with a partner is an agent as well as a principal of the other partners for the purpose of the business of the firm. When he enters into any contract in the name of the firm, right, he binds the firm if the act is done in the name of the firm and it is done in the ordinary course of the business of the firm. If these two conditions are fulfilled, then even if the firm did not derive any benefit out of that contract, it is still the firm who is liable. So this is known as implied authority. If the act is not done in the usual course and in the name of the firm is not liable. But if the other partners ratify it, then in that case, the firm is liable. What is not considered? What is acts beyond implied authority? Beyond implied authority means a partner cannot do these acts. And if a partner does these acts, the firm is not liable. Right? If a partner does these acts, the firm is not liable. Now, when I say act of the firm, what do I really mean by act of the firm? Act of the firm means any act which is done by all the partners, or any act which is done by any one or more of the partners, or any act which is done by the agents of the partners. Then it binds the whole firm. Now, what is act beyond implied authority? That means if a partner does these acts, the firm is not liable. When I say acts beyond implied authority, what it means is if a partner does these acts, the firm is not liable. So, what exactly is acts beyond implied authority? He cannot submit a dispute to the arbitrator. That means if there is a dispute between the partners, can he hire? I repeat again, can he hire a lawyer? Yes, but he cannot hire an arbitrator. He cannot open a bank account on behalf of the firm in his own name. But let us say if the partners give him the authority to do that, can he do it? Yes. So these acts cannot be done by a partner, and if he does, the firm is not liable. But if the partners have, by an express agreement, decided that a partner can do these acts, or if it is in the custom of the firm or the business, then if a partner does the act, the firm is liable. Otherwise, these acts do not hold the firm liable. So he cannot open a bank account in his own name. But the partners tell him that you open it in your own name because you are the one who's operating. Then in that case, can he do? Yes. He cannot compromise or relinquish any claim or portion of a claim by the firm. That means if someone owes money to the firm, let us say he had to pay 10 lakh. He says, okay, you pay 5 lakh. This is compromise. You cannot do. Normal cash or trade discount is different, but this he cannot do. Hey, yo, you don't have to pay anything. Go enjoy money. Can he relinquish? No, he cannot completely give up on the debts. If any case is filed on behalf of the firm, he cannot take back the case. Taking back the case is before the verdict is given, you take back the case. He cannot take back the case. He cannot take back the case. If any case is going on against the firm, he cannot speak out against the firm in that case. He cannot sell or purchase immovable property in the name of the firm, and he cannot enter into a partnership. That is, let's say XYZ is a partnership firm. They want to form a single partnership with ABC. They approach A. A says, yeah, we are ready. Who are you to decide? This is a decision which will be taken by the whole firm, not by A alone. So he cannot enter into a partnership on behalf of the firm. But can I give a partner a little more or a little less authority? Yes, we just saw acts beyond implied authority can be done by a partner if there is an agreement. So a partner's authority, that is, he can be given a little more or a little less authority. But how does it, but this is something which is internal to the partners. So how does it affect a third party? How does it affect a third party? So if the third party knows about the extensions or restrictions, the third party is bound. Bound means if knowing it, he still makes a contract with the partner, he cannot hold the firm liable. He knows, let's say, A cannot take a loan of more than 1 lakh on behalf of the firm. D knows about this, but he still gives A loan of 1.5 lakh. So you know A cannot take a loan of more than 1 lakh. You're still giving. It's your fault. So the firm is only liable for 1 lakh to you, not more. On the other hand, F doesn't know about it and he gives a loan of 2 lakh. He can recover the whole of the 2 lakh. So any extensions or restrictions can be done by express agreement. An outsider dealing with the firm will be bound by such restrictions if he has knowledge about such restrictions. Will be bound by such restrictions if he has knowledge about such restrictions, right? Now, emergency, acts in emergency. If in an emergency, a partner is not able to communicate with his other partners, and to protect the interest of the firm, he takes a decision. Is the other partner, are the other partners liable? Yes. Even if he acts outside his authority, if the act is done with a motive to protect the interest of the firm, the other partners will be liable and they should indemnify him for the work that he has done. So in an emergency, even if a partner does any act which is outside his authority, the whole firm will be liable if it was done to protect the interest of the firm. Any admissions made by a partner, okay? Any admissions made by a partner, that is in the ordinary course of the business, he speaks out about anything, right? In the ordinary course of the business, if he speaks out about anything, the whole firm is liable. So he sells the goods making some claims and that claims are false. Then can the third party sue the firm? Yes. Any admission made by a partner in the ordinary course of the business shall be binding on the other partners. Correct? The next one, notice to a partner. Notice here doesn't mean a written notice. Notice here means the knowledge of any fact. Notice means knowledge of any fact. I repeat again, notice doesn't mean the written notice given to a partner. Notice means the notice of a fact. The notice of a fact. Now, when we talk about notice, if in the ordinary course of the business, when the active partner is dealing with the firm, it is deemed that the whole firm knows about it. I repeat again, when the active partner is dealing on behalf of the firm and he gets to know about anything, it is deemed that the whole firm knows about it. But this should be a real notice. That means if he knows about it and he uses that information to cheat the other partners, then in that case, the other partners are not liable. So let's say he purchases some goods on behalf of the firm which are a little inferior than what the firm uses. In that case, it will be deemed that the whole firm knows and the whole firm is bound by it. But he purchases a little inferior just to cheat the other partners. Then the other partners are not liable and they can even return the goods back. Liability to third party. We have three liabilities here: contractual liability, liability for tort, and liability for misappropriation of cash. If the firm existed, and when the firm existed, the partners have done any act, they remain liable even after its dissolution. That means even after the dissolution of the firm, the partners can be sued individually. The partners can be sued individually. Correct? Liability for torts. Tort means a civil wrong. If a partner has committed any torts, okay, if a partner has in the ordinary course of the business, that means I am doing the act in the ordinary course of the business and with the consent of the other partners. The partner's consent was not given to commit a tort. The partner's consent was given to do the act. If I commit a tort, the whole firm is liable. If I commit a tort, who is liable? The whole firm is liable. So let's say we give one partner an authority to do the work, and that partner does not do the work or he misapplies the money, the whole firm is liable. Misappropriation of cash. A third party has to give cash to the firm. He gives the cash to the firm and one of the partner personally uses that cash. He takes off that cash and uses it personally. Or if a partner has to give, like if a third party has to give cash to the firm and he gives the cash to a partner on behalf of the firm and that partner misuses it. In both the cases, in the first case, obviously the money was given to the firm. In the second case, even though the money was not given to the firm, it was still given to a partner on behalf of the firm. So in either of the cases, the firm will be liable. Now the last topic, dissolution of partnership. Dissolution of partnership is basically what? Reconstitution of partnership, right? Dissolution of partnership is basically what? Reconstitution of partnership. When I say reconstitution of partnership, that basically means there is a change in the PSR. And that happens when a new partner comes in or an old partner leaves the firm, right? That happens when a new partner comes in or an old partner leaves the firm. So when we say reconstitution of partnership, it can happen by admission, retirement, death, insolvency, expulsion, and transfer of shares. The first one, admission, when a new partner joins the firm. The new partner can join the firm either with the consent of all or by express agreement. So either I should have the consent of all the partners or there should be an agreement which says that a partner will join on this day. When a new partner joins the firm, he is liable from the day he joins the firm. Right? His rights as they decide, joins the firm, is liable from the day he joins the firm. So a minor is liable from the day he was admitted to the benefits of the firm, whereas a new partner is liable from the day he joins the firm. Let's say he agrees with his other partners to be liable from a prior date. That is, let's say he joins here. Let's say he joins here, but he says, I'll be liable from here. Even if he agrees to be liable, the third party cannot sue him. He is liable only to his other partners, not to the third party. Third party will only sue the old partners. The old partners can sue him for his share of loss, but the third party cannot directly sue him. But yes, if the old contract is cancelled, that is old partners and third party contract is cancelled and a new contract is made between him the new partner, the old partners, and the third party. Then they can sue him. But otherwise, they cannot sue him. Retirement. What is retirement? Retirement is basically a partner leaves the firm. He can leave the firm with the consent of all, or with express agreement, or by notice in case of partnership at will. The retiring partner will get the share of profits, right? If so, whenever he retires, no, his account should be settled. If the firm continues its business without settling his accounts, then he will get his share will be treated as a loan, and he will get interest on loan. Or in such a case, what will happen is he will get subsequent share of profits. When he retires, instead of can he carry the same business as that of the firm? Yes, he can carry the same business as that of the firm if the agreement does not stop him. If the agreement says you cannot carry a same business, then he cannot. Otherwise, he can carry the same business if the agreement does not stop him. When a partner retires from the firm, instead of taking his share, he can actually sell his share to any existing partner. And if he sells his share to any existing partner, he will have no further claims over the firm. Insolvency. When a partner has his personal assets are less than his personal liabilities, he's insolvent. The day a partner is declared insolvent by the court. So here the court has to declare him insolvent. The day the court declares a partner as an insolvent, he ceases to be a partner of the firm. I repeat again, the day the court declares him insolvent, he ceases to be a partner of the firm. Whether the firm is dissolved or not, he is no longer a partner of the firm. His assets will not be used to pay the firm's liabilities. And even if the firm is not dissolved, he is no longer a partner of the firm and his liability comes to an end. But he will not get any share of profits from the firm because we will use his share of assets to pay off his liabilities. Correct? So basically, he'll have no rights or liabilities. Death, a partner is dead. We don't need anything here. In case of death, the firm is dissolved. So insolvency and death are two cases where generally the firm is dissolved. But if partners want, they may continue. They may continue, right? When a partner is dead, his legal heirs don't become the partners of the firm. Unless if they have an agreement that yes, the legal heirs will become the partner, then it's a different case. Otherwise, the legal heirs don't become a partner of the firm. They can become only if the other partners agree. What are the rights? Obviously, partner is gone. The rights are not to the partner. The rights are with the legal heirs. So what are the rights of the legal heirs? They will have a share of profits. If the accounts are not settled, they will get subsequent share of profits, or their share will be treated as a loan and they will get interest on loan. Or they can sell off the shares to an existing partner and then they will have no rights over the firm. So if you see, it's the same as retirement, but in retirement, it was given to the partner. Here, it's given to the legal heirs. Liability, we already know legal heirs have never got any personal liability. So the liability is up to their share, the estate. The property of the deceased partner is liable for the acts of the firm before his death. Expulsion, when we throw a partner out of the firm. For expulsion, I need majority consent. So till now, it was consent of all. Here, it's majority consent. Express agreement. Express agreement means the agreement gives the power, the right of expulsion, that if needed, a partner can be expelled. Now, in case of expulsion, when we talk about expulsion, in case of expulsion, the most important element of expulsion is good faith. So it should be consent of majority, agreement, and good faith. In fact, if the expulsion is not in good faith, expulsion is null and void. What is good faith? First, it is in the interest of partnership that the partner is being expelled. He's served with a notice that we are going to expel him and he's given an opportunity of being heard. Only after that, if we expel him, the expulsion is valid. When a partner is expelled, he will have the same rights as in the case of retirement. Transfer of shares. Can a partner sell his share or give his share as a loan, as a security for a loan? Yes, that is transfer of shares. When a partner transfers his shares, again, I need the consent of all, or there should be an express agreement. In case of transfer of shares, the transferee who takes the shares of the partner, please remember he does not become the partner of the firm. So when I say transferee, what are the rights of the transferee? Can he will he get a share of profits? Obviously. Can he take part in the business of the firm? No. Can he check, inspect, and copy the accounts of the firm? No, because you're not a partner. On dissolution, he will get his share. But till today, you were not letting me check the books. So, what is my right here? He will get his share, and to determine his share, he will be given a statement of affairs as on that day. One example that I want to discuss here before we end this topic is this. A, B, C, D are partners of a firm. They are using this property, and this property has been rented in A's name. Okay? A retires from the firm. Does this rent agreement automatically transfer to BCD? No. The fact that the partner has retired from the firm and the property in which the business was carried on was in his name, the retirement does not result in the assignment of the tenancy rights in favor of the other partners. Okay? With this, we are done with the revision of second unit. In the next video, we'll see the revision of the third unit. Keep studying, happy learning, and stay motivated. Thank you so much.